Item number are there is 85 of 922. This is Criminal Appeal 5 of 2022. See Ashok Biswas versus State of West Bengal. State of versus State. The operative portion I am reading. Considering the entire aspect, considering the materials on record, and considering the law laid down by the Honorable Supreme Court, I am of the view that the observation of the learned special court regarding the particular facts and circumstances of this case is not justified. The order of conviction passed by the learned special judge in this case is not at all conformity with the provisions of law, and it is liable to be set aside. Accordingly, the criminal appeal being number 5 of 2022 is considered and allowed. The order of conviction and sentence passed by the learned special judge against the appellant, namely Ashok Biswas, in sessions case number 3 of 2020, is hereby set aside. Appellant Ashok Biswas is hereby acquitted from the charge level against him under section such and such. The appellant is in custody. The appellant be set at liberty at once. He is on bail. The appellant is on bail. The appellant be set at liberty at once. The COTs standing in his favor are also released. The COTs standing in his favor are also released. They are disposed of. Section 40, para 47. Para COTs are also released. Para 40. Para 40. I'll say send down that once. The correction cost. Next. Item number 2. CRR 23. This is the judgment. Why say why possible? You just read out. CRR 21 of 2023. Considering the entire facts and circumstances of this case, it appears to me that the learned magistrate has taken cognizance of the offence on the basis of Naraji petition filed by the respondent. The learned magistrate also issued the process after being satisfied of the evidence adduced before him by the witnesses on essay. Thus, I find no infirmity at this juncture to cause the criminal proceeding. The value of evidences as assessed by the learned magistrate adduced before him by the witnesses cannot be assessed by this revision court. I find no merit to interfere with the criminal proceedings initiated with the learned magistrate. Criminal revision hereby dismissed as devoid of merit. Item number 3, CO 15 of 2023.
For the petitioner, my lord.
I am reading out the operative portion.
My lord.
After clinical observation of the order passed by the learned district judge, it appears to me that the learned district judge actually refrained the petitioner number 1 to make further construction over the suit property till the disposal of the suit. I further make it clear that the order of injunction was passed in a nature of status quo in respect of nature, character, and possession of the suit property as on this day. The learned district judge observed that injunction order is required to protect the interest of the appellant and also to restrain the petition number 1. So that she may not make any further construction over the suit property. I find no infirmity in the finding of the learned district judge in passing the impugned order. I further observe that the order has directed the learned trial judge to, for a specific time within 6 months for disposal of the suit. Let the learned trial judge carry out the order. I find the petitioner would not suffer any irreparable loss if the impugned order allowed to be continued. Civil division is hereby disposed of.
Grateful, yeah. My lord.
Item number 4, PLR 16 of 2023.
On the last day, your worship has fixed the matter currently.
Yes.
Your worship, in that case, the proceedings will fail. I am satisfied with it.
Without presence of Mr. Binu Kumar, no order can be passed, madam. Fixing the first day of circuit.
Yes.
Let the matter appear in the, please take down. Let the matter appear in the first day of the next circuit. Next available
Okay.
circuit. Item number 5, WPA 918 of 2023.
My lord, I have filed my CAN application with duly affirmation that for addition of party. This is the last day of the circuit, my lord.
Scan is not in the list. Union.
But as I have received the copy yesterday of the writ petition, I need to file a formal CAN application for addition of party. In that event, let my addition be allowed, my lord, and maintainability point will be kept open.
Mr. Jaipal is there. Okay, let's just wait. Let him come. Let him know what he said. Item number 6, WPA 976 of 2023.
For the petition in this matter.
Lordship, this may be passed over for a while. Other matters can be taken up.
Okay, pass it over. Lordship. Item number 5 and 6, pass over. Item number 7.
I am for the respondent.
of 2020.
The appellant has to find the paper book.
Is this MSCC matter? Whether they have filed paper book?
No.
Not filed. Let the matter go out of the list.
Let it
Next tablet.
My lord, my senior is appearing for the petition.
What is your submission? What is the paper book?
It will be get ready by next circuit.
Okay. Very good. Let the matter be listed in the next table.
Oblige, my lord.
Item number 8, February 4 of 2020.
My senior is appearing in this matter also.
Same order, next table.
Oblige, my lord.
Item number 9, WPA 85 of 2020. Next table circuit. Item number 10, WPA 91 of 2020.
My lord, Venus is appearing for the petitioner. My lord, he is out of station. I am paying for next circuit.
Same order. Item 11, WPA 109 of 2020.
My lord, my senior is appearing. Pray for next circuit.
Next circuit.
Oblige, my lord.
Item 12, WPA 110 of 2020.
My lord, Venus is appearing for the petitioner. My lord, I am praying for next circuit.
All matter be named next circuit. Anything ready? Mr. Lal? Anything there? Any matter from item number 31 to 103? Any urgent matter? Very good. Yes,
He's having a hearing before court number 1.
call the passover matter. Other matter ready. Passover matter, item number 5, WPA 918 of 2023.
But I'm for the writ petition.
Yes.
Lord, on that day, Mr. Shatandru was out of station.
Yes.
I have just argued the matter. I've just opened my case. I can recapitulate the point.
Not necessary.
My lord,
Today can application was filed.
My
What
lord.
can be done?
my lord. Let that be taken up as on day's list, lordship. Let that be allowed. And we can, I'm pressing for an interim protection, lordship. I have copies, advance copy has been served. So far as writ petition copies, because it has been given to the other.
No, if I want to pass an interim order, I have to hear out the matter.
My lord.
So that can be hard.
Yes, my lord. Yes, my
That
lord.
can be hard.
Yes,
entirely,
yes.
If you are ready.
Yes, my lord. Yes. My lord.
I have already heard it. Let them.
Very good. I will.
Eligibility of the writ petitions and-
I have gone through the merits of this case.
Yes, my lord.
Merits of this case. This is the one lady applied for the post of some
Labor inspector.
labor inspector,
My lord.
appeared in the examination,
My lord.
stood first,
My lord.
and there was some interview also.
My lord.
However, thereafter notification came.
For cancellation,
For
there,
cancellation.
no, there are two parts of the impugn notice. First thing, cancelling the written exam. To that extent, they may ask for exchange of affidavit. But it has to be thrashed out upon affidavit. But the later part, for conducting interview on 10th of next month, I'm praying for interim protection. Because this court is in the season of the matter. So kindly see that impugn. I'll just show, Lord.
What is the notification?
It's at page 98.
Yes.
My lord, I'll just place page 19. It's very, I'm sorry, my lordship, even I could not read it, but I will place it, my lord. It is at the box middle, my lord. It is hereby inform all concerned that the written examination conducted on 19/8/2023 at Andaman Law College for filling up of 2 numbers of regular 1 and anticipated 1 post of labor inspector group B non-gazetted pay level -6 rupees 35,400 -11,2400 stands cancelled due to administrative reason. This is one part. The other part is re-examination in computer-based test CBT mode will be conducted on 10/11/2023 Friday at Debrate, Port Blair. All eligible candidates are requested to visit the portal details given to download their admit card. Now, if this court holds it to be maintainable and this has to be decided on affidavit, the former part needs to be considered. I cannot pay interim to that extent. The court has to consider those. But the later part of the impugn notice is concerned, fixing
Former part means?
a former part cancelling the written exams on administrative reasons, because they may say that this needs to be by way of an affidavit. They may say on that day Mr. Dubey said so. But the latter part of the impugn notice fixing 10/11/2023 to be the date for fresh de novo examination, there I am claiming for interim protection. That should not be done because these both things have to be decided at one shot in this proceeding. That's my point.
So how you deprive? You have also appear, you are also liable to appear.
No. That the former part of cancelling is bad in law. Why it's bad in law, my lord? Every knows every order must contain a reasoning.
No, let the examination be conducted subject to the result of the writ petition.
No, my lord. That would amount to prejudging the issue. But that would amount to prejudging
They
issue.
shall not pass any, I'm that, they would not.
No, my lord. This may not be done, my lord. My lord needs to pass an order.
So let me
In one other way, my lord.
let me
Just one
address.
second, sir, just one second.
Yes,
I'm yet to
sorry,
complete.
sorry.
So this is my prayer. I have.
How you suffer? If you appear in the examination, appear to be on 11th like that, so how you?
No,
suffer?
already
They
exams
pass.
were done, results were published.
Maybe there is under the discussion of this court,
For the-
whether it will be there or not.
For the same thing, why a second time examination? My point is, when the screening committee, being the expertise in the field, have clearly notified the publication, being
No,
the.
you have not obtained any right like that.
No,
You know,
it's an it's an administrative action I've challenged here.
Yes, you have, you may have challenged, you have to file affidavit like that.
My lord, but
But it is-
I'm on lordship that the exam, because most days are ensuing vacation, puja vacation, forthcoming. The next circuit is from 16th of this month. Now, these things need to be considered, because this was argued by the other side that it's a service matter. I would take most of the administrative tribunal act also. It's not a service matter. If this court holds against me to be a service matter, I have to be relegated back to the tribunal. Then the judgment of
I want to understand how you have suffered.
I would be prejudiced in the way, my lordship, I am the top one qualified man.
I know,
My lord.
I know.
My lord.
If it appears that the first conduct of the authority was correct,
My lord.
then you would be happy.
No, my lord.
First,
But my lord, those aspirants who were below me, who secured less mark, that is in gap of 20, and some of them were absent. Well, kindly come to the written results one. How I would be prejudiced, I would demonstrate with this document. Well, kindly come to that once. Written results. I'll show that.
That is the merit I have.
But the prejudice flows from there. The question of prejudice flows from there. If I'm, as what is following from my lord, that if my client is given liberty to attend exam de novo in terms of the impugn notification, the position would be, I have lordship forgone my right in this writ application first. Secondly, some of the candidates who secured less mark, they are far away from me. I have secured above 60. They are below 40.
I understand.
But lordship, and some of them were absent. Some of them were absent on the day. This tantamount to inviting them again. This would tantamount, not kindly appreciate one thing. There were claims and objection called for after the written results were published within a certain date. Nothing was done on that day. Nothing, because
Okay, I understand.
this is one more thing.
This is your issue.
This is my point, and there are a few more judgments apart from which I have submitted on that day. This is in the case of, I'm just placing lot. Yes, ma'am. So these are three judgments.
T.K. Rangarajan, you have submitted.
My lord, Rangarajan, and there is one judgment of Tina Islam of this court in this in the matter, which has some resemblance, and these are three other judgments of this court. One by Honorable Justice Arindam Sinha, one by Honorable, these two are by Justice Aniruddha Roy. Shashikala Khatija. So that's my point, Your Worship.
Islam in respect of extension and like that.
But this point was raised. They argued before this court, since it pertains to service matter, the writ court is outside the
Okay, regarding
jurisdiction.
maintenance.
Maintainability.
Okay, no, they have not raised anything before me regarding maintenance.
But on that.
No, I will.
I am hearing.
No, we are arguing.
Yes, they are,
Let me
in one
make my
voice, they are
point.
saying that they would be raising it.
Yes.
That's my point of, that's my point of
It's
argument.
not like that, my lord. I'm just,
No, this needs extensive hearing.
No,
So today it cannot be heard. I want to hearing about the, I want to hear about the preliminary, you just
My lord.
order anything, any order of stay like that.
no, prima facie, I have a
Prima
case.
facie, I am asking
The
you anything.
requirement, the sine qua non.
Yes,
is-
and just, may I just very broadly indicate, my lord?
Yes,
First point, my lords, that there is an issue of maintainability because my lords, Honorable Supreme Court Constitution Bench in L. Chandrakumar has held that at the first instance, my lords, the Central Administrative Tribunal is to be approached. A party cannot directly approach the High Court. Para 93, my lords, of this judgment may be seen. Para 93, my lords, page 308. And on top, page 48 in the small electronic 48 and running 308. Whereas the Supreme Court has said, before moving on to other aspects, we may summarize our conclusions on jurisdictional powers of tribunal. The tribunals are competent to hear matters, even where the question of virus of statutory provisions are questioned. However, in discharging, they cannot act as substitutes for High Court and Supreme Court, which under our constitution setup have been specifically entrusted with such obligation. Their function is only in respect to supplementary, and all such decisions will be subject to scrutiny before division bench of the respective high courts. The tribunals will consequently also have power to test, because this was on the higher issue that even virus can be challenged. However, this power will subject to one important exception. Tribunal will not entertain any question regarding virus of the parent statute, following settled principle that tribunal is a creature of an act, cannot declare that very act to be unconstitutional. In such cases alone, the High Court concerned may be approached directly. All other decisions of these tribunals rendered in the cases that they are specifically empowered to adjudicate upon by virtue of parent statutes will also be subject to scrutiny before division bench. We may add that, this is very important, my lord, we may add that tribunals will, however, continue to act as the only courts of first instance in respect of areas of law for which they have been constituted. By this, we mean it will not be open for litigants to directly approach the high courts, even in cases where they question the vagaries of statutory legislation, except as regards, as mentioned, where legislation which creates the particular tribunal is challenged by overlooking jurisdiction of the tribunal concerned. So, my lords, except where the constitutional validity of the Administrative Tribunals Act is challenged, in every other case, the tribunal has to be approached first. And now the question which my learned senior has raised, that this is not a service matter, my lords may have the Administrative Tribunals Act, my lords. The Administrative Tribunals Act, 1985. My lord, we have got copy, I can pass a hand over. My lord may have the first, the definition of service matters, which my lord will find section 3, clause Q, subclause Q, service matters. Subclause Q, my lord, service matters in relation to a person means all matters relating to condition of service in connection with affairs of union or state or of any local or other authority within territory, as respects 1, remuneration, 2, tenure, including confirmation, seniority, promotion, reversion, premature retirement, superannuation, leave, disciplinary matters, and 5, any other matter whatsoever. So the definition is very wide. And now my lords may have section 14, which lays down the jurisdiction of the, my lord, Central Administrative Tribunal. My lord may see section 14, which is in chapter 3. Same as otherwise expressly provided in this act, Central Administrative Tribunal shall exercise on and from the appointed day all the jurisdiction, powers, authority exercisable immediately before that by all courts except Supreme Court in relation to A, recruitment and matters concerning recruitment. Recruitment is specifically covered. Recruitment and matters concerning recruitment to any All India service or to any civil service of the union or a civil post under union or to a post connected with defense or in defense, in either case post filled by civilian. And B, all service matters relating to All India service to any person not being member of All India Service or person referred to appointed to any civil service under union or any civil post under union. 3, a civilian not being member appointed to any defense service and pertaining to the service of such member. Then likewise, my lord may see point C, all service matters relating to service in connection with affairs of union concerning person appointed to any service or post. Then my lord, therefore, this the power of the administrative tribunal, my lords, is specifically provided on the matter of recruitment. So recruitment is specifically covered under the jurisdiction of the CAT, my lords, and therefore in view of L. Chandra Kumar, they cannot at the first instance approach the High Court. Likewise, my lords, the full bench of the Calcutta High Court, my lords, has also passed a judgment. This is in the case of Avdesh Singh. My lord, this is a larger issue regarding not only CAT but also in respect of labor matters. Now, my lords may just have paragraph 35. Thus, High Court will have no jurisdiction to adjudicate upon merits of case relating absorption, regularization, reinstatement, continuance in service, page 11, my lord. In relation to in service of such employees with respect to affairs or controversies as contemplated within the purview of Act of 1985. The cases have to be filed afresh before Central Administrative Tribunal or Industrial Tribunal or Labour Court at the option of the employees. So, my lord, this is on the point of jurisdiction. Now, my lords, objectively speaking, my lords, my duty is to assist the court, my lords. So, my lords, what is the law, my lords? I can only assist the court dispassionately without taking either side because I am representing the government. Now, my lords will see what is the scope of interference, my lords, in these matters. My lords, this is a very specifically squarely applicable judgment, my lord. And this I'm not relying upon this to take a partisan stand, my lords. Let's just see, my lords. This judgment specifically deals with the issue where, my lords, recruitment process is carried out and subsequently, my lords, the recruitment process where the power of the government or the recruiting agency to cancel the recruitment process and to have a fresh recruitment process. What are the circumstances, my lords, in which it can be challenged? Now, my lords will see. My lords will just see, my lords, 14, paragraph 14. Or my lords will just see the facts a little bit because, my lords, this is very similar on facts also. This is very similar on facts also. My lords may see paragraph 3 or rather paragraph 2 onwards. The senior divisional personnel officer East Coast Railway Visakhapatnam issued a notification proposing to conduct a written practical typewriting test for filling up the vacant post of chief typist in the pay scale of 5,500 to 9,000. In response, as many as 12 candidates appeared in the test held on 30th October 2006. The result whereof was announced on 22nd November 2006. Some of the candidates who failed to qualify such a representation complaining about the manner in which the test was conducted, alleging that defective typewriting machines provided to them placed them at a disadvantage vis-a-vis candidates declared successful. The successful candidates also appear to have made a representation impressing upon the authorities to go ahead with the interviews and to complete selection process expeditiously. Since they did not happen, OA was filed. Now, as we see in this case, CAT was approached first by one of the successful candidates for a declaration direction about the respondent to proceed with the selection. Now, my lord, this was the factual matrix, and my lord may just see now what the court says on the legal question. My lord may have para 14. Now, my lord will see para 14. It is evident from the above that while no para 14, my lord, is on page 7.
Yes, got it.
It is evident from the above that while no candidate acquires an indefeasible right to a post merely because he has appeared in the examination or even found a place in select list. In this case, only the results have been declared, the marks have been declared, there is no list. Yet the state does not enjoy. Now, this is an observation which will help my other side. Yet the state does not enjoy an unqualified prerogative to refuse an appointment in an arbitrary fashion or to disregard the merit of candidates as reflected by the merit list prepared at the end of the selection process. Again, I reiterate, there is no merit list here. The validity of the state's decision not to make an appointment is thus a matter which is not beyond the judicial review before a competent court. If such decision is indeed found to be arbitrary, appropriate directions can be issued. To the same effect is decision of this court in duty of Chandigarh versus Dilbagh Singh, where again this court reiterated that while a candidate who finds a place in select list may have no vested right to be appointed to any post, In the absence of any specific rules entitling him to the same, he may still be aggrieved of his non-appointment if the authority concerned acts arbitrarily or in a malignant manner. That was also a case where selection process had been cancelled by Chandigarh administration upon receipt of complaints about unfair and unjudicious manner in which the select list for candidates for appointment as conductors in situ was prepared by the selection board. An inquiry got conducted into the said complaint, proved the allegations made in the complaint to be true. It was in this backdrop that actions taken by administration was held to be neither discriminatory nor unjustified, as the same was duly supported by valid reasons for cancelling what was described by the court to be dubious selection. Applying these principles to the case at hand, there is no gainsaying that while the candidates who appeared in the typewriting test had no indefeasible or absolute right to seek appointment, yet the same did not give a license to the competent authority to cancel the examination results in arbitrary manner. The least which the candidates who were otherwise eligible for appointment and who had appeared in the examination that constituted a step in aid of a possible appointment in their favor were entitled to is to ensure the selection process is not allowed to be scuttled by malignant reason or arbitrary manner. It is strike law that Article 14 strikes at arbitrariness, which is an antithesis of the guarantee contained in Article 14 and 16. Whether or not cancellation of the typing test was arbitrary is a question which the court will have to examine once a challenge is mounted to such action. No matter, the candidates do not have an indefeasible right to claim an appointment against the advertised post. Now, my lords, very significantly, my lords may now come straight away, my lords, to paragraph 31. So also whether the competent authority ought to have conducted an inquiry into or verification of the allegations before passing an order of cancellation is a matter that would depend upon the facts and circumstances of each case. It may often depend upon the nature, source, and credibility of the material placed before the authority. It may also depend upon whether any such exercise is feasible, having regard to the nature of the controversy, the constraints of time, effort, and expense. But what is absolutely essential is that the authority making the order is alive to the material on the basis of which it purports to take a decision. It cannot act mechanically or under an impulse, for writ court judicially reviewing any such order cannot countenance the exercise of power vested in public authority except after due and proper application of mind. Any other view would amount to condoning a fraud upon such power which the authority exercises the same holds in trust only for exercise of legitimate purpose and along settled principles of administrative law. The next question then is whether the selection should be finalized on the basis of test held earlier or the matter be allowed to be re-examined by authority in context of representation received. In our opinion, latter course would be more in tune with the demands of justice and fairness, especially when second test has been conducted with which all the in-service candidates have appeared. The result of this examination test has not, however, been declared so far, apparently because pendency of these proceedings. If upon due and proper consideration or representation received from candidates who were unsuccessful in the first examination, the competent authority comes to the conclusion the test earlier held suffered from infirmity or did not give fair opportunity to all the candidates, it shall be free to pass an order cancelling the said examination after recording such finding, in which event the second test conducted under the directions of the tribunal will become the basis for the selection process to be finalized in accordance with law. In case, however, the authority comes to the conclusion that earlier test suffered from no procedure or other infirmity or did not cause any prejudice to any candidate, second test examination shall stand cancelled and process of selection finalized on the basis of the test held earlier. Now, my lords may see in this case. So therefore, my lords, the judgment clearly contemplates that, my lords, the authority can hold the second test. My lords, nothing stops eventually. And what is the distinguishing factor is there any reason? In this case, my lords, there are detailed reasons recorded in writing, my lords, which will show that, my lords, I'll have to file this on affidavit, but my lords, today I'm appearing before the court. It is my duty to inform the court. My lords, there are detailed file notings and recordings. Detailed file notings and recordings, which will show that, my lords, there were reasons, my lords, there are the reasons recorded by the authority, my lords, because of which the test has been cancelled, my lords, is that as many as 24 questions were found to be wrong. So, my lords may straightaway have page 74. My lords may straightaway have page 74 of this compilation. Now, my lords, upon receiving the objections by the various unsuccessful candidates, my lords, the department has applied its mind, my lords. We see that question number 8, valid objection. Then question number 9, valid objection. So where it is not valid, it has been rejected. But if my lord goes through this entire list, my lords, as many as 24 questions have been found to be wrong. So if the questions are wrong, my lords, the authority is within its rights to cancel. And my lords, there is a judgment which is specifically applicable to this case, my lords, very identical circumstances, my lords. The Honorable High Court of Chhattisgarh, my lords, has held, in fact, in a writ proceeding, my lords may straight away have para 68. Considering, my lords may see para 68, which is on the second last page, considering the degree and percentage of defects in the question paper, which according to this court, as much as 41 wrong questions answers have been found out of 100, the percentage of which would certainly dilute the mode of selection process, and the court cannot observe the silence. Court after the examination cannot allow it as one horse race, but would accept the steep challenge with an idea to reform. Serving certain problems required multi-pronged approach and reform, and they will persist if we view through narrow lens, and carelessness will always have a price. Consequently, the test by pursuant to advertisement is hereby quashed. The PSC is directed to conduct fresh examination on the basis of advertisement held to all candidates who have appeared in the examination and filled up the forms. No separate examination fee shall be charged. So, my lord, the High Court has exercised writ jurisdiction as on the ground that questions were wrong. So, my lords, I have a good case on merits. Therefore, my lords, they will have to get a stay. My lords, they have to, first of all, get over the threshold of the jurisdictional challenge. Secondly, they have to satisfy that an examination cannot be cancelled where as many as 24 questions are found to be wrong. As my lord has said, my lords, if my lord is keeping the preliminary objection open and all these issues are to be decided, my lords, everything will always abide by the result. And as has happened in the Supreme Court matter, the second examination can be conducted. And my lords, obviously, whatever happens in the second examination will abide by the result if they succeed here. And the candidate who has filed the petition is a meritorious, very capable person. She has come first in the first examination. For all you know, my lords, in the second round also she'll come first. So where is the question, my lords, of injuncting a written examination on 9th and 10th of November? Everything will abide by the result. Maybe on 11th November, we'll be so happy to inform the court that the petitioner has succeeded even in the second examination. There will be no need to pass an injunction, my lords, and there is no merit list today. The further processes have not been carried out. Interview has not been conducted. Only an examination, my lords, the results have come out. Let the exam be conducted, my lords. It will naturally abide by the result. And tomorrow, I am sure there is a good possibility that they will come and inform the court that they have succeeded in the second examination also. If there is such a large difference in marks, I'm sure that the candidate is may come out as brighter even in the second round. Every possibility of that.
Yes.
My lord, I'm on behalf of the added respondent here. My lord, I'll go with the submission of my learned brother on the side of respondent. On the
Now,
same
who
time,
are
I
you?
would request my lord, like,
Who are you? Who are
I'm
you?
the added respondent.
Added respondent.
My lord, may kindly come to Article 323A of the Constitution.
He is with which respondent, state respondent or the Union of India? I am not.
No. I can't be with you.
Not with the respondent.
Administrative Tribunal, got it, my lord?
We are referring article.
323A, capital A.
Okay.
Yes.
Administrative tribunals. Parliament may by law provide for adjudication or trial by administrative tribunal of disputes and complaints with respect to recruitment. Admittedly, the writ before my lord is challenging the recruitment process, entire thing which was initiated by the respondent, local respondents of this island. That has been under challenge before my lord. So it is categorically mentioned even in the Administrative Tribunal Act 1985 that section 14 says any recruitment process is challenged and it has to be filed before the Central Administrative Tribunal. Even the Constitution says so. And the power of High Court in the Constitution is entirely on a different footing. Now, regarding my lord, the selection process which has been challenged. This is one judgment of 2021 Supreme SC 123. My lord, may kindly see the head notes. Selection constitutional values which I'm referring it. Please take a note of it.
Right.
No, you have not given a copy to me.
Citation and reported judgment. not
Sorry.
reported.
Yes. One second. I don't have basic law. Please wait for it. Wait for it. It is 2021, volume 4, Supreme 198. By Justice Dhananjay Chandrachud and M.R. Shah Lordship. Kindly see the head notes. Selection constitutional values which undergirds Article 14 and 16 mandate that selection process conducted by public authority to make recruitment have to be fair. Now, as stated by the other respondent, that 24 questions were wrong in the written test. Transparent and accountable. Selection involves intense competition and there is no threat of individual who tries and bend rules to gain an unfair leap in the race. Irregularity in the process give rise to misgiving over whether process has denied equal access to all. Sanctity of selection process comes under a cloud. Detection of individual wrongdoing by candidate may result in action being taken to exclude those whose credential or performance is tainted. But when entire process is tainted, authority in charge of conducting it may decide to cancel selection as a whole. Needs to be preserved public confidence in and sanctity of the selection of public posts and recruitment of observing fairness to candidates who invest time and resource in attempting to clear through a selection. Both these considerations have constitutional foundation going beyond service and administrative law principles. That is para 2. Now, my lord, may kindly come to C. Service law. Selection. Fairness to candidate who participated in the process is an important consideration. Recruiting authority is entitled to take a bona fide view based on material before it. That entire process stands vitiated, as a result of which a fresh selection process should be initiated. Integrity of selection process cannot be lightly disregarded by High Court, substituting its own subjective opinion on sufficiency of material which has been taken into account by decision-making authority. Now, 24 question as reflected in the reply and document placed before my lord, that 24 questions out of the entire questionnaires appears to be wrong. The answer key was wrong. Then obviously it is up to the authority to take a decision. There may be situation where candidates who have indulged in irregularity can be identified, and it is then possible for authorities to segregate taint from untainted candidates. On the other hand, there may be situation where nature of irregularities may be more manifold and number of candidates involved is such of a magnitude that it is impossible to precisely delineate or segregate taint by untainted. A considered discussion of authority based on material before it taken bona fide should not likely be interfered in exercise of power of judicial review unless it stands vitiated on the ground of unreasonable or probabilities. Now, my lord, may kindly come to the last paragraph, that is D. Cancellation, selection process cancellation. Gravamen of charge in present case is not in regard to taint with attached to a specific group of person, but to sanctity of recruitment process as a whole. Recruitment to public service must command public confidence. Persons who are recruited are intended to fulfill public function associated with functioning of government. Where entire process is found to be flawed, its cancellation may cause hardship to a few. Here also it is for few, who may not specifically be found to be involved in wrongdoing. But that is not sufficient to nullify ultimate decision to cancel an exams where nature of wrongdoing cuts through entire process so as to seriously impugn upon legitimacy examination which has been held for recruitment. Both High Court and Tribunal have erred in laying exclusively focus on report of second committee, which was confined to use of impersonation. Judgment of High Court and Tribunal are set aside. Now, DSSB and GNCD must now take adequate measures to ensure against recurrence of such instance which erodes credibility of and public confidence in recruitment process. Para number 55, 57 and 60. So in the present case in hand, as the respondent, he has placed the document where it was said that there are 24 questions out of the entire questionnaire appears to be wrong. In that event, my lord, putting a stay order against the new selection process obviously is definitely will infringe the right of the other candidates, and it will appears to be confirming the wrong committed by the respondent authorities while conducting the previous exams. This is my humble submission.
Just one submission I wanted to
I'll
add.
just set us on law point.
No, I'm not, I just want to, this is my last one sentence. My lords, if the petitioner is permitted to participate, it will obviously be without prejudice, my lords. What my learned senior submitted, that barely because she participates in the second examination, the writ will become infructuous, my lords. That is not the case, my lords, because you can always participate without prejudice to your rights and content.
I am appealing for the Union of India.
Yes.
My submission would be kindly come to page 59 of the writ application. A vacancy notice was there. And statement of marks is there at page 62. Then claims and objection is there at page 94. Now, at page 62. At page 94, my lord, the name of the 94 is the notice where the names are there, and there is a mark obtained is at page 61. Marks obtained by the parties at page 61. At 61.
Yes.
Now, everything is within a time limit, a time was prescribed within which the objection was to be given. And probably it was not given within time. Thereafter, a notice was published that is dated 24th August 2023. My question would be whether, of course, I will come back with proper instructions, because I understand they say at this stage that 24 questions was incorrect, assuming it for the moment, not admitting. Will they are going to fix the person who has created this problem? Responsibility will be fixed. Secondly, now, second question, whether after going through all this process, whether they can stop it, whether in the notice it has been mentioned, what is the reason for that? Is it not arbitrary? I have gone through the submission of friend that so far that the second judgment is concerned of where the typewriting mistake is arbitrary. Absolutely, this goes against the gentleman, against the state, against the respondent. Let me come back with the instruction, and I hope that where the exams are conducted, kindly understand the mental economy. And merit list is published. Whether anybody is given appointment or not is a different issue. One of the person is a topper, another person is at the lowest level, and another is absent. So if you are not, if my lord permits the calling a second interview as proposed by the state, then the person absent, he will get a right, which he has no right at all. He will not have a right at all. So lot of complication will develop. Why at this stage? Is it not arbitrary? Administrative reason. Is there something behind the? Let me take the instruction from the Ministry of Home Affairs. I will come back.
Yes.
No, my lords, just one. As my learned senior is appearing for the state, my lords. He has spoken as a true officer of the court, my lords. He has every right to.
I will
respect
take
that,
proper
my lords.
instruction from the
But I am
Ministry.
only
will come
submitting
back.
that for the purposes of today, my lords, it is my learned senior is appearing for the union. So my lords, that may be borne in mind. Now, my lords, page 17 and 18, my lords, of the report which I had filed, I'm just responding to these concerns. The objections were received within time. It is not as if objections were not received within time. 2nd September and 3rd September, the objections were received. Page 17 and 18 of that compilation which I gave.
Yes.
Objections were received within time. It is not as if objections were not received within time. Last date was 3rd of September.
Right.
Which your lordship
I do
will find
understand.
page 62 of the writ petition. But which was received within time, my lords. But these are things which you will have to place on record by way of affidavit, my lords. And
That's true.
that is assuming your lordship says that the preliminary objection regarding jurisdiction is to be decided finally, and not my lord doesn't dismiss it on that ground or granting them liberty to go to CAT. That in only the situation where we have to address the court on merits, in that situation, my lords, all of
Yes.
these will be placed on affidavit.
Just reply on law points.
Yes.
Nothing on facts, no papers, I will show. Now, the first judgment which Mr. SUBHENDU has relied is of our High Court, presided by 3 judges bench. So it kindly turns to the paragraph which the adverse side has relied. I'll go with that only. It was inspired with this paragraph. I'll rely upon this paragraph, my lord. And paragraph is 35. At the cost of repetition, my lord, these 5 lines need to be pasted once again. Paragraph 35. It's a judgment in the case of Avadesh Singh by their.
Yes, got it.
My lord, page 35.
Paragraph
Thus-
35.
35. Thus, the High Court will have no jurisdiction to adjudicate upon the merits of the case, directing absorption, regularization, or reinstatement oblique continuation in the service. Now, this matter pertains to these 4 aspects. Absorption, this is not the case here. This is not the case of regularization or reinstatement in the present case, which has been taken out by the petitioner, or this is not the case with regard to the discontinuation of service. Next, my lord, in service of such employee with respect to the affairs of the controversies as contemplated within the purview of Act of 19. The case has to be filed afresh before this and next. Next, my lord, there's one thing I'll just show. This is one first judgment which says this is with regard to, in fact, stricto sensu, I would say, this relates to a service matter. This is not the case here. This is the first judgment of this Avadesh Singh is distinguishable on facts. Not judgment is an authority on the point which is decided. The slightest of difference, fact, would make authority very difference. The facts one which was before their lordship, before the 3-judge bench, was entirely different with that of the one which is before my lord. This first judgment. Secondly, my lord, this is 2010 SS 7 SCC 678 was revised, East Coast Railway. Well, I'll get show. Even this goes in favor of the petitioner. Paragraph 31 was revised heavily. In paragraph 14 at page 684, it is evident from the above that while no candidate acquires an indivisible right to post merely because he has appeared in examination or found a place in a select test, yet the state does not enjoy an unqualified prerogative to refuse an appointment in an arbitrary fashion or disregard to the merits of the candidate as reflected by the merits list prepared at the end of the selection process. The validity of the state's decision not to make an appointment is thus a matter which is not beyond judicial review before a competent writ court. If any decision is indeed found to be arbitrary, Lord, the catch is arbitrary. Lord, would kindly see my writ application. I've taken a specific stand. Ex facie, the impugned notice is arbitrary and suffers from vice of arbitrariness. So this judgment, on the other hand, comes to my aid. If there is an arbitrary, palpable arbitrary, the court can interfere under Article 226. So facts is different notion. If they say that the ratio has to be taken, the ratio is this. Not kindly this the compilation which they have relied. I'll just show that compilation. But kindly see at page. I'll just show page upon which they relied.
74.
74. I'll start with 70. Yes. 74. Just one second. Lord, this, Lord, they are landing in a problematic, Lord. The authorities, this would indicate that in the past selections were done in the same way. This, they are inviting the problem. By showing this, their own view, they are landing in a problem. Now, page 74 says, well, just 2 questions. I'll take one of 2 question numbers at serial number 7. Question number 23. It's not just 1 second. Yes. Question number 23. Valid objection. Answer key. Option C is incorrect. Correct answers is option B. Now, before finalizing the questions, an expert body was deployed in every selection process. Lord. It's not that any Tom, Dick, and Harry can choose a questions they have to put to the candidates. No, it was duly approved by the competent authority. It is upon an approval. These are being brought in papers. Those candidates attended. But these things have been done here in the present case. Questions were not in a competitive exam, but not most. The tricky questions are there. The questions will be tricky. One has to catch it. What is the trick in that? The questions which we are putting are not tricky. Just to assess the skill of the candidates or aspirants who are appearing. This has been done. But the authority is taking U-turn. The authorities, my lord, kindly see the modus operandi and the audacity, I would say, my lordship. They take a decision that no, we will going to conduct a fresh exam based on belated objections being raised by some of the aspirants who secured less mark. Those aspirants have no right because they are unsuccessful. Supreme Court is very well clear on this point. Those unsuccessful candidates even cannot raise this objection. Far to say, my lordship, approaching a court. Even objection cannot be raised. I brought that judgment. If they are unsuccessful, they cannot turn around, they can say. At best, they could have raised the protest. Because not it's my specific case, the entire exams, right from the sitting till the examination is over, it was all videographed. It's my writ petition. If they had any protest, they could have raised at that instance. They foregone. They foregone. Now, this action should not be, lordship, but anything would amount to endorsing arbitrary action, lord. It's my humble prayer, some protection, lordship, which I have framed.
Yes.
One line, my lord. By way of added respondent cannot claim assert his right. He has to file a separate writ application.
You only allowed.
If he has-
Very.
This one my lords, may have the writ petition page 52. This is the original vacancy notice, my lord. Pursuant to which all these candidates 6 May 2023 notice. My lords will see paragraph 2 at page 52, list of eligible and ineligible with reason candidates to appear in written examination be published on portal. This is regarding the first page. And now my lords will straight away come to point 6 at page 55. And fifth point, the Andaman and Nicobar administration reserves the right not to fill up all or any of the post vacancies advertised here in above without assigning any reason. But this is a case where, my lord, there are reasons. So, my lord, the administration, my lord, has the rights and, my lord, the power to cancel and the administration process, the process of examination. And, my lord, this is pursuant to this notice that all of them are participating. And, my lord, the situation where there is arbitrary action, my lord, the tribunal and this court can interfere. But what is being submitted is here, there is a genuine reason, my lord. There are 24 questions that are wrong. And all these things have to be placed on record by way of affidavit. My lord, either, my lord, they should be relegated to the cat, or if your lordship keeps our objection open, then, my lord, in that situation, my lord, interim order may not be passed, because as in Supreme Court case, they can participate in the examination, and, my lord, whatever happens will abide by the result, my lord. Why should the
We are governed by the English philosophy, the king does no wrong. Here the wrong, all wrong is committed by the king.
Yes. Very hard. Please take down. The present petitioner appeared in a routine examination conducted on 19th of August 2023 for the post of labor inspector. Full stop. Assistant Labor Commissioner. What is the post? Labor inspector. Labor stop. After such examination, a result of the written examination was published, wherein the petitioner scored first. He also appeared in Viva Voce.
There is no Viva voice.
There is no Viva Voce.
No, only written examination.
No, what is the notice dated 24th August 2023?
This is not page not,
Testimonials,
but verification of
page,
documents.
page 94,
Verification of documents.
verification documents.
Documents at page 94.
Okay,
A list of talking on the list of talking.
Has not been done, even that has not been done.
okay. That was notice, invited.
You also appeared in the Viva voce.
Get it now. So one notice was served to the office of the Labour Commissioner dated 24th of August 2023. 24th of August 2023. Inviting successful candidates with their credentials for the preparation a list of top 3 merit aspirants. Merit aspirant candidates by the team constituted for this purpose. Suddenly, one notice was issued by the Assistant Labour Commissioner in the Daily Telegram dated 14th of October 2023, declaring the fact that the examination conducted on 19/8/2023 stand cancelled due to administrative reasons. The present petitioner is before this writ court with a prayer that the notice at the Daily Telegram dated 14th October 2023 is arbitrary and the same need be stayed. The same need be stayed. The same need be stayed. Stop. We further argued that the present petitioner has scored first position in the selection list properly conducted by the authority. If the examination which would be proposed to be held on 10th of November 2023 is conducted, the valuable right of the present petitioner would be infringed. Stop. Learned advocate appearing on behalf of the respondent authority submits that the notice submitted by the submitted in the Daily Telegram, published in the Daily Telegram, is not arbitrary. There are good reasons for cancellation of the said examination, said written examination dated 19th of August 2023. The authority wants to use affidavit with some documents. Stop. The authority also argued that the instant writ petition is not within the jurisdiction of this court. It is within the jurisdiction of the CAT, Central Administrative Tribunal, according to the provisions of Section 14 of the Administrative Tribunal Act 1985. The learned advocate for the Union of India, Mr. Lal, submits that the entire process of examination was conducted by the authority, and the entire exercise of the taking examination and publishing result cannot be wiped out by the said notification, by the said notice published in the Daily Telegraph. However, he intends to seek necessary instruction from the authority, from the Union of India in this respect. Heard the learned advocates peruse the citations submitted by the parties, also peruse the materials on record. It is true that the present petitioner has appeared in the examination and stood first stop. It is also true that she was invited to place his credentials. It appears that by the impugned notice, the examination dated 19/8/2023, written examination dated 19/8/2023 was cancelled, and candidates are asked to appear in re-examination in computer-based test, which will be conducted on 10/11/2023. Whether there is any arbitrariness in issuing the notice by the concerned authority has to be looked into in the latter stage after exchange of affidavits between the parties. In my view, the present petitioner, who are not specifically debarred to participate in the examination, cannot argue the point that his valuable right has been infringed. Considering the same, I refrain myself to pass any interim order against the said notice passed in the Daily Telegraph. Stop. I further observe that the authority concerned shall not publish any result. Authority person may may take the re-examination as which will be conducted on 10/11/2023, but they are hereby directed not to pass any result of such examination till the disposal of the instant. All the points of law are kept open, and the matter will appear peremptorily in the next circuit.
Okay. My addition of party may kindly. Let that be taken as a
Let the CAN application be listed. Be listed. It was not listed yet. Be listed in the next circuit along with this application.
My lord, just one request, where my lord has said, the answer is there into formality. Where my lord has said that my lord's till the disposal or until further orders, my lord.
Yes. No.
That may.
Or until further order, whichever is valid.
Yes. Or until further orders.
Whichever is.
Whichever is valid.
Yes.
Whichever is fine.
Next passover matter.
Item number 6. WPN 976 of 2023.
My Lord, in this matter, I appear on behalf of the respondent bank. I'm sorry I could not join the, first call. because the link was not available. I'm, my lord, I've got it. My lord, I'm appearing for the respondent. I'm opposing this writ petition, lordship.
Lordship, I appear for the petition in this matter.
I'll be assisting senior counsel, Mr. Menon.
You are appearing.
For the
Yes,
back.
I am. Miss Jinu is appearing with me.
Mr. Menon and Ms. Zinu both are appearing for the back.
What is the issue here?
Lordship, the issue is that I have already filed an application under section 17(1) of Surface Act before the DRT consent back in Kolkata. Way back in the year 2021, the number is SA 21 of 21. And thereafter, the matter has been kept dormant for quite some time. It was just being adjourned as because there was no PO to take care of the matter. Now, this instant matter has been fixed before the DRT2 in the month of March, that is 21st of March 2024. Annexure P7 in page number 49 may kindly be seen. That is the status of the Surface application which I have filed. It has been obtained from the online portal of DRT.
P7.
Annexure P7, page number 49.
Yes.
Lordship 1, 2, 3, 4, 5, 6, 7. Lordship 8 line. Next listing date, that is 21/3/2024.
SA number 21
One
of 2021.
Yes, that is my main application, which was
Very
filed.
Next
Now-
listing date 21st of March 2024.
2024. Now, what has happened, Lordship, in between, now in the month of October, that is this month only, on 5th of October 2023, the respondent bank published an auction notice dated 3rd October 2023, wherein they have offered to sell out the secured assets of mine by way of auction on 6th of November 2023, that is next month. Now, what is happening, like tomorrow on, even the DRT will go on holiday. I spoke to the court master as well yesterday, day before yesterday. He said the same thing, and moreover, PO is also not there. Nobody is in charge also. So I have filed interim applications, being interim application number, one is for put up, another is for injunction. That the receipts may be found on page number 59, annexure P10 collectively. Annexure 59, that is here, the diary number of my interim application is 1428 of 2023. Page number 59 and 60. One is for put up, another filing is for injunction. Now, I have filed both these applications, but it cannot be heard at this point of time, even not before the date of auction. Now, at this situation, I am being left remediless. So my constitutional rights are being infringed. Now it can only be safeguarded by this honorable court, Lordship. That is the reason I am before this honorable court. That till the time my applications before the DRT is heard and disposed of, I may be given some protection till that point. I am at the verge of losing everything, Lordship. Some protection may be given because tomorrow on everything is going off. Till 15th of next month. Only on 16th it will open. And thereafter also there is no news as to when the new PO or anybody else will be given a charge. Even Mr. Menon knows that we have confronted each other on several matters before DRT in video conference, because earlier the DRT Shiliguri was in charge, and that was till 20th of September 2023. That was the last time, and thereafter no one else is there in charge of DRT2. So I'm completely in a remediless situation. My constitutional rights to exert my rights before the DRT2 may kindly be preserved, protected, Your Honor, till the time I am heard there. I am aware that any matter pertaining to Surface cannot be decided by this honorable court, Lordship.
Yes.
It is clear. But till the time I have heard over there, Lordship, I should be able to exert, I should be able to exercise my right, which is given by the Constitution. Unless and until I am being allowed to do that, then my right will be infringed. And only forum which can protect me from that particular situation is this honorable court. And this is the last day, Lordship. I'm praying I may be given some protection, Lordship. There are several aspects, several more aspects to this. Lordship, my conduct may be seen. Since the very beginning, I have been trying that there should be a one-time settlement. To that effect also, certain documents I have filed.
Lordship,
Determine the surface matter, this court within have no jurisdiction.
no jurisdiction, Lordship, but to
Only to consider your valuable right, natural
Lordship,
justice, or
absolutely
natural
correct.
justice that can be heard. Okay,
Lordship.
so I am not interfere with the merit of this matter.
It cannot be.
Okay, so why, Mr. Jinjin? What can be done in this situation?
Some protection for some time.
My
Lordship.
lord, my lord, may I submit?
Yes.
With due respect, my learned friend. My learned friend mentioned about filing of section 17 application under sections, my lord, under the SURFACE Act.
Yes.
Lordship, the availment of and creation of mortgage has not been disputed. There is no dispute of availing 4 crore 55 lakhs loan. Now that is not on this. Now what happened, my lord? The account became MPA in 2014 or 15. Thereafter, my lord, I issued a notice under section 13(2) of the SURFACE Act. Now, my lord, that notice, they replied. They replied, and I made they sent a representation which was dealt with. Now that has not been mentioned in the petition. Not only that, my lord, this writ petition, my lord, the writ petition has not approached this court with clean hands. He has not disclosed many facts, material facts, and your lordship knows the Honorable Supreme Court has repeatedly said that it is an extraordinary, equitable, discretionary jurisdiction, and the petitioner has to approach the court with the full facts. Now, what happened? My learned friend mentioned about section 17 application. I tell your lordship, the 17 application was filed, my lord, in 2021. Thereafter, the same points were taken before DRT, whatever they say. Now, DRT did not pass any interim order. Now, what interim? On that occasion, I am showing your own lordship 2-3 orders passed by DRT. They admitted the liability. They said we will approach the bank and we will try to settle the matter. Now they send a proposal which was not acceptable to the bank. Now that proposal, he availed the law as on today. As on 21st January, the claim was 8 crores 31 lakhs. Today, with the interest, it has gone up further. Now what happened? This application was filed in 2021. No interim order was passed in. They prayed for, interim order stay. Now, not order to pass. My learned junior, Miss my lord, will produce the order. Order dated 25th February 21, passed by DRT. This is way back in 21. It was stated the tribunal is of the opinion that if the applicant is so keen about settlement, they are at liberty to approach the defendant bank along with a concrete proposal with a reasonable upfront amount within 30 days from the date of this order. What they did, they offered 6 crores without any upfront payment. So bank could not, my lord, consider that. Thereafter, my lord, kindly, if your lordship has got the orders passed by DRT, then thereafter an order was passed on 22nd December 2021. Now, they said, in the meantime, what happened? They submitted another offer, making an offer of 5.5 crores, whereas earlier offer was 6 crores. Then that was also not considered. Now, lordship, kindly see the order passed by DRT on 2nd May 2022. Learned Advocate Counsel for the Defendant Bank. And he submits that previous settlement proposals said to have been made have been rejected by the bank. Learned Counsel representing applicant submits that the applicant is keen about settlement and prays for further opportunity. Such prayer is considered. Let the applicant approach the defendant bank along with revised compromise proposal with an upfront payment of 10% of the 13(2) notice within 15 days from the date of this order for status of the settlement, if any, and no settlement takes place, hearing it matter will be heard and decided on merits. Now, in spite of this, what he did, he submitted another proposal of reduced amount without any upfront payment. No, bank could not, and there is no interim order as on today. Now, my lord, lordship will kindly appreciate. We had made 2 attempts in the past for the sale. Now, they had approached the bank, DRT. They could not obtain any order against the stay. Unfortunately, this sale could not take place because in the first attempt, there was only 1 bid, which could not, because of that, bank could not accept. In the second bid, there was no bid. Now it's a third attempt. We are coming because it's a public money, and how can he forestall the sale? Now he is not coming out with, and moreover, your lordship kindly see the context. I am showing in the IA file before DRT on 12th October, my lord, they have annexed a circular of the central bank, Reserve Bank, for OTS, one-time settlement scheme. Now they are saying their statement is they are ready to settle the matter. Their statement, I am telling you, I am reading. This has been suppressed in this writ petition. Kindly, I am reading 2 paragraphs, your lordship. Paragraph 8 of this was filed on 12th October, this month only. That the applicants on numerous occasions expressed, I don't know whether my junior has given your lordship that IA petition. Possibly, I'll read out. Your lordship, kindly permit me to read out.
Read out.
That the applicants on numerous occasions expressed their willingness to resolve the disputes with the defendant bank and accordingly requested the bank to accord the benefit of one-time settlement of the loan account. However, the defendant bank till date did not give it a serious thought. Now, that recently on 8th June 23, the Reserve Bank has issued a notification with the heading as framework for compromise settlement and technical write-offs, which allows and or gives liberty and or encourages the state cooperative banks and also to do one-time settlement with their borrowers. And hence, the applicants accordingly pray that the respondent bank may be given a direction to settle the loan accounts of the applicants in terms of the said framework for compromise settlement and technical write-offs issued by the Reserve Bank of India. And thereafter, this honorable tribunal may pass compromise decree as settled between the applicants and the respondent bank. The copy of the framework for compromise settlement and technical write-off issued by the Reserve Bank is annexed here too. So in spite of this, your lordship kindly appreciate, they have not come to court with clean hands. They have not, there were 3 orders. Sorry, there were 3 orders passed by DRT. You approach the bank, with upfront payment, no upfront payment. They are offering 5 crores, 6 crores, whereas it has now become 11 crores. My lord, my respectful submission, bank is interested to settle the matter, but they should make a reasonable offer, term offer, and they should come. My lord, we cannot accept any settlement contrary to the Reserve Bank guidelines. Now we are inviting them. You come and they don't want to make payment. They have enjoyed 5 crores. Years back, they have utilized the money. They are carrying on business, being full profit. Now you say that COVID, that, business loss. My lord, this application, my lord, this aspect has been suppressed from the court. And your lordship, I stress this, Honorable Supreme Court has said in the recent judgment 2022, 12 SEC 815, Constitution of India 226. This is judgment of Abdul Nasir Krishna Murari. Article 226, abuse of process of law, fraud on court, extraordinary equitable discretionary jurisdiction of High Court. While invoking this jurisdiction, petitioner must approach court with clean hands by disclosing all material facts within his knowledge. They have suppressed the DRT orders. They have suppressed the Reserve Bank guidelines, OTS of scheme. And now they have annexed some letters and saying that it is fixed, DRT has fixed it in 2024. So this thing, my lord, we cannot wait. It is the public money, as the cost of repetition, I say, it is public money. We cannot, how long they will? Let them come, let them approach the bank tomorrow with the offer. We will welcome them. We are welcoming them. We want the money back. It is a public money. We have accepted the deposit from public. They cannot enjoy this money, proper money like this. We have no other option but to invoke the SURFACE action. Let them come out with a proposal. We have no objection. We welcome them. This is what we really want. But they cannot, in a circuitous way, come and say that, last sale is fixed on such and such day. We want to stay now because this has been going on for 3.5 years. In
Yeah.
spite of repeated opportunities given, they did not submit
Page number.
any, concrete proposal with the upfront payment. So
That
in my respectful submission, my lord, and moreover, Lordship, I have one submission. I know that DRT is not functioning and the in charge is also not there. I can understand, I'm not joining issue. But under the provision, DRAT has the power to allot the, if they make an application, DRAT, appellate tribunal, sitting in Calcutta, has the power to, direct, transfer the matter and to hear the up to DRT 1 and
Page
2.
number 58,
DRT
P9.
1 and 3
May
are
kindly be seen.
functioning.
That is the auction notice.
Yes.
Lordship, the reserve price may kindly be seen. Now, just before my learned brother has mentioned that we have offered an amount of 5.5 crores, 6 crores. Absolutely correct. We approached the bank even before the bank issued a notice under section 13 subclause 2 demanding the amount. The amount reserve price may kindly be seen. It's 5 crore 45 lakhs 21,600. That is the reserve price. This price is lower than the price what we have offered as one-time settlement. Now, regarding one-time settlement, we have approached the bank on several occasions for one-time settlement. They said that they do not have any provision for one-time settlement in their bylaws, and that is the reason they cannot do it. If we get some order from this honorable court or from DRT, they are ready to do it. That is what the thing is.
No, DRT has passed the order for one-time settlement.
No, it hasn't. It said that you approach the bank, and whenever we approach the bank, they say, no, we cannot do it. Before the court, they will say, no, we are ready to do it. Let them pass a concrete order accordingly and say, communicate. Lordship, and one more thing, Lordship. The thing is that now, in order to get an interim protection, I'll have to demonstrate that the balance of inconvenience and convenience tilts in my favor. Now, these are all something to be agitated before the DRT, which I have done. And my learned friend spoken about 2 interim applications. Lordship, those became infructuous as because due to paucity of bidder, and another was as because there was only one bidder, which did not work out. Due to which the interim application, it became infructuous and disposed of. Now, one-time settlement, we are ready. We have been ready since a long time. Now, firstly, my loan accounts were termed as NPA in the year 2014, as per their own document. But I have been served with a notice under section 13(2) only in the year 2020. Annexure P5, page number 32, may kindly be seen once, Lordship. This is a law point, complete law point, which I have agitated before the DRT also. Solely on this ground, the SURFACE proceeding has to be quashed there. The date of this particular notice may kindly be seen. Top right hand side, 26/5/2020. This is the first demand notice they have issued. On the same day, because I had 2 loan accounts, page number 35 may kindly be seen, P5 collectively. It also bears the same date, 26/5/2020. Page number 35. Similar notice, Lordship. Only for 2 different accounts, they have issued 2 notices. Now, these notices were issued on 26th of May 2020. Now, Lordship, as the Lordship knows, that SURFACE Act gives unfettered power to the bank. It's like they get a shooting license, something like that. But subject to compliance with certain provisions which is laid down in SURFACE Act. One such provision is section 26D. That may kindly be seen, Lordship.
No, I have no jurisdiction to entertain this.
Lordship, I'm aware though. I'm aware of that. Only to show that I have a meritorious matter, Lordship. 26D, it says right to enforcement of securities. Notwithstanding anything contained in any other law for the time being in force from the date of commencement of the provisions of this chapter, no secured creditor shall be entitled to exercise the rights of enforcement of the securities under chapter 3 unless the security interest created in its favor by the borrower has been registered with the central registry. Now, their own document. Lordship, page number
page number 38 may kindly be.
You are
Entering into
inserting in the merits.
Merits.
Okay,
Lordship.
I am not going into the merits.
Lordship, in that case,
I am just in a place to see your protection of natural justice. Okay.
Lordship,
So at this juncture, I am passing a specific order. You proceed to the bank in one-time settlement. If it is within the ambit of jurisdiction and the condition laid down by the Reserve Bank, they may have it. So
Lordship,
in that case,
Lordship, I have already placed it. For that, they will have to, it clearly says, I have already placed it, I have given the copy. Because
whether you have approached the bank?
I did on several occasions.
No. After
no,
some, no.
Lordship, I did, and they, on all occasions, they said that as because their own bylaws don't say anything about one-time settlement, they are unable to do it. That's what they said. Now, in terms of this guidelines, which is a mandatory one, it says that regulated entities. Earlier, state cooperative banks were not in the list. Now, this time on 8 June 2023, even state cooperative banks have also been included in this. Now, they also can do one-time settlement or a compromise
Yes,
settlement.
go to the bank. Go to the bank, I am passing the order.
Lordship, but till then, some protection may be given in
Before
auction.
the day, no, you cannot sit tight.
Lordship,
cannot-
because
So
in
that-
terms of that,
The
this
date
thing,
is- Date is fixed on 11.
no, 6th of November, Lordship.
6th of November.
But what about my application before DRT, Lordship? Those are not being heard before that. I have all the right to exert my right over there. But I am unable to, as because
They are proceeding before the CRT in respect of your two loan account. So if the two loan account was on time settled, then what is the purpose of proceeding?
that is there, Lordship. But if
but
it
may,
not work
may I
out,
sub-
if
may I
it,
submit?
Lordship, I may be allowed for
Yes, yes.
Lordship. If it does not work out, then they are going to auction on 6th and I'll be on road. And without having an opportunity, because these points and all, it can be decided only by DRT. Unless and until I am given an opportunity over there, Lordship, my right will be curtailed.
Very hard.
Lordship, I may be given some protection till the time it is heard before the DRT, Lordship. Even a direction may be given, because on an earlier occasion, when I was similarly circumstanced for another, one of my other client, this honorable court was pleased to pass an order directing the DRT to take my application for hearing. Lordship, may I place that order? It was passed by the honorable justice.
Not necessary. Your DRT is not functioning. Okay,
Give me one copy.
hard. The present writ petitioner is a party to a proceeding before the Debt Recovery Tribunal within bracket DRT 2 Calcutta, Kolkata. Wide S number SA/21 of 2021. Topic is the submission of the learned advocate for the petitioner that the bench of the DRT has not been constituted yet.
No, it has been considered, it is not functioning now, Lordship.
It's not functioning, that's
Okay,
all.
not the bench of the DRT is not functioning now due to the paucity of the PO. Stop. The present petitioner has filed two applications before the in the said proceeding, being a put up application and one application for injunction in respect of one e-auction sale notice issued by the respondent bank in the Daily Telegram dated October 5, 2023. Stop. The e-auction sale notice fix the date of e-auction on 6th of November 2023. The learned advocate for the petitioner submits that his petition of injunction. Injunction was filed, but there is, as there is no authority to hear out the that application for injunction, and there is a arguable ground in favor of the present petitioner. So till the matter be heard by the concerned deity, the sale auction, e-auction sale notice dated dated October 5, 2023 need be stayed. Next, learned advocate for the learned advocate for the petitioner further submits that the present petitioner became remedialess as the DRT is not functional. So at this juncture, one appropriate order need be passed by this revision, by this read court. So, learned advocate appearing on behalf of the respondent cooperative bank submits that the matter pertains to the debt recovery tribunal, and the instant read court has no jurisdiction to enter to the merit of the said case. If further argued that the that after initiation of the before the learned DRT, no interim protection was given to the petitioner. Stop. He again pointed out that the proposal of one-time settlement as argued by the learned advocate for the petitioner is not conformity with the rule and
Guidelines
guidelines
of this.
by the Reserve Bank of India.
And we had rejected it with the grounds, with the reasons.
So it is not possible for the bank to adhere to the proposal of the present petition. He further submits that the money pertains to the public money. The same e-auction need be conducted on the day. But the learned advocate peruse the materials and the documents. It appears to me that the demand notice under section 13 within bracket 2 of the SURFACE Act was served upon the present petitioner on in the month of May 2020. The said stop after such service, the application was filed before the learned debt recovery tribunal, Calcutta, right? SN number 21 of 2021. Admittedly, the concerned DRT 2 has not passed any interim protection in favor of the petitioner during the pendency of the said proceeding. Stop. It is true that a person cannot be Rome remedialess. Thus, an appropriate order is required, but at the same time, it has to be looked into that the petitioner must have approached to the concerned bank to with the proposal which can be in their admit to admit. Stop. I think at this juncture, I think it necessary not to pass any interim measures. interim order in favor of the petitioner. Rather, the respondent cooperative bank, state cooperative bank, is direct to reassess the proposal of the present petitioner if he placed within a fortnight to the bank, if it appears that the proposal is applicable according to the guideline of the Reserve Bank of India, they shall accept it, and consequently the sell notice is not required to be executed. On the above observation, the writ petition is disposed.
But my right to agitate before the DRT, it is being, because I had merit, Lordship. If I am not able to argue on merits,
My lord, the same points had been taken in the essay application also in 21. I don't know why my learned friend is, same point had been taken and that was rejected, considered and rejected by the DRT.
Lordship, but no one is there to hear there.
You proceed.
No, in 2021-22. Lordship, I'm deeply obliged, Lordship.